Gee, the last couple of weeks, this going live here seems to have been delayed, but I assume I'm live here. Hi, folks. You're with Tacitus today, your pushback channel, and thank you for joining this radio live stream. In this essay, I'd like to talk about the how ideology has penetrated the deepest and darkest recesses of rape law, rape trials, rape cases, the definitions of rape, how the evidence of rape should be heard and applied, and so on. It's now become, I believe, it's now become an ideological sort of circus, and there's a rape case going on currently, and I won't mention the name of the case or where it's being heard or the name of the people involved, or even all the facts that are involved, but rather approach the this as an opportunity to talk about my views on rape trials generally. Now, there was a time, before law became ideological, where and before I even go to that, rape trials is right, right on the bullseye of social power as the ideological fanatics would see it. So it's in the gender war that the globalists and their two-bit flunkies are always trying to push on the West, in the gender warfare. This is right on the fault line. It's an emotional thing to the radical feminists, for example. Now, I should add that most of the radical feminists that scream and cry about rape are in fact lesbians. They're not straight women, which you'd think it would be straight women, as they'd be, you'd think in a bigger danger, going out night clubbing or dating or that sort of thing. But no, it's the lesbians that make the kick up the biggest stink about it. I mean, go figure. So so this back in the day, rape had to be that you were tied up or threatened. The proverbial gun was held to your head and that sort of thing, or you had to be physically overpowered, beaten up, or there had to be some very clear control that the other party had over you before you could really go down in the path of rape. So now, rape has always been considered a serious crime. It's never been something that's not been considered seriously. It's been very clear, though, that the accuser must prove, and that's the way it works, by the way, in the legal system. The accuser has to prove, if the state takes up the case, they must prove their case beyond all reasonable doubt in a court of law in front of an independent judge and jury. Now, if the accused is found guilty, then they can spend many years in prison. The rapists are spending 10 or 15 or more years in prison. It's a very, when you're going to deprive someone of their liberty, then it's an important matter, and it's only appropriate that the accuser be required to prove their case. Now, ideology has crept in, and the feminist ideology is that women should be predetermined as a victim because of their social power. They have less social power than the man, therefore they must be sort of predetermined as a victim before the case even starts. Now, this creates a layer of prejudice against the man who's being accused before the case even kicks off. So now there are other things the woman can say, the woman making the accusation can say, well, I feel scared, I feel frightened, I feel fear, which again, this is a big plank of lesbian feminism, that all women must have freedom from fear, but without defining either fear or freedom, what freedom from it constitutes. It's one of those ideological things that sounds good, like the folks in the French Revolution, liberty and equality, while they were cutting people's heads off. So it's one of those catchy slogans that no one knows what the fuck it means, but hey, sure as hell sounds good. So women are entering these cases, rape case in a court, already with a really they're victims, and the burden of proof ever so subtly moving just a few degrees every year or so, moving a few degrees along. So really, the woman no longer is required to prove her case. The burden of proof that she has to meet has been lowered and lowered and lowered and lowered. So there really needs to be only just sort of a general balance of probability. And that's enough to get over the line. And I've seen cases sort of like that where there's no witnesses, there's no injuries, there's no proof of anything, and yet they're still getting convictions, which is absolutely astonishing to me. But nonetheless, so now once someone's accused of rape, then they're effectively guilty till they can prove their innocence. That there's a few issues now with definitions of rape. For example, there can be general agreement that the parties had, adults, had consensual sexual relations, but she had a couple of drinks. And so she can claim after the fact, well, I was actually a little bit, that the alcohol had affected me. So legally now, she can say, well, even though I gave my consent, I had those couple of drinks. So legally, it wasn't consent because I'd had some alcohol. But what about him? He had alcohol. Maybe he legally wasn't asking for your consent, or maybe he legally thought you had given it, or maybe he legally didn't know you had too much to drink, or so you say. There's no definition of how much alcohol, what the effect of the alcohol was, and therefore what constitutes giving consent. So there are other things. For example, if someone would be taking party drugs, they can say, well, I gave my consent, but it wasn't informed consent, therefore it's still rape, even though it was consensual a moment ago. So there can be all sorts of things like that which can affect the outcome. And these are things that have been demanded by the feminist lobby and which have been written into, in some cases, law, and in other cases, jurisprudence, or in other cases are an ideological backdrop in the overall court proceedings. And I never like those. If it's not clearly codified, then in my view, at least, it cannot be used as a framework or indeed as a law to go and imprison somebody or deprive them of their liberty. Laws must be clearly and absolutely codified, and so there's nothing ambiguous about them, and then applied on the basis of that clarity. And this is not the case. There's a lot of, a bit like in the divorce courts, it's all very ideological and all social power, and she's a victim before, and that sort of crap. So there's a lot of that ping-ponging around. Now, it may be easy to get an activist jurist or not, but now the other trick that's used is you try and have the case heard, the rape case heard in a court that is going to be, and is proved to be, exceptionally sympathetic to the accuser, and very unsympathetic to men, yet all men are rapists. Damn fucking fascist Nazi Hitlers. And that adds in yet another layer of prejudice against the accused. And now, in some cases, you can sort of shop around. We can say, well, are we going to we're going to have the case heard where the alleged rape took place, the jurisdiction of or are we going to have it heard where the parties live, or where this party lives or that party lives. So there's an element, at least, of discretion. So you shop around for the court that's going to be most sympathetic to the accuser, and you decide to have the case heard there. And there are situations where that occurs. Now, just like when there's climate change activists have their case heard, it seems to be stunningly remarkable, just incredible how the courts magically seem to find the judge that's going to be most sympathetic to the climate change activist and won't fine them, won't imprison them, barely gives them a finger wagging, in some cases even tells them they're doing great work. Now, it's not possible to have that many sympathetic judges to hear that many climate change cases, climate change activist cases, but somehow they do it. So there's no reason to believe that they can't find a sympathetic judge, sympathetic to the accuser, that is, even though the evidence is flimsy. So now this also raises an issue when there's an activist judge with particularly if there's a rather vague frame of reference along ideological lines that he has social power but she doesn't, therefore, and this sort of nonsense. It's quite possible that the judges can just arbitrarily raise the burden of proof on the man and arbitrarily lower the burden of proof to the woman, so that, for example, and I'm not saying this is or has or hasn't happened, but the judge can say, well, all you need to do, Billie Jean, is prove that you were in the city, the building at the time. That's all you need to do. But you, Billy Bob, you have to prove you were not even on planet Earth at the time if you want to get off this. So they can lower and raise the burden of proof to make it easy for one party and much harder for another. And make no mistake, they do that sort of thing. Not necessarily in a criminal case, but certainly in ideological sort of courts. Now, increasingly, the rape courts are ideological courts, so it's changed the very nature of jurisprudence. They've kept the idea that the man can go to prison and lose his liberty, but they've changed it almost into a civil case in terms of the amount of evidence that's needed to gain a conviction. So now, in one imaginary case, I'm going to quote here the two young, the two youngish people, they're at work, and they're having there's a party at work. They've had a few drinks. They go off into a side room. There's no claim that anyone was forced to go in the side room. They have one party apparently fell asleep, woke up, and then claimed that they'd been raped. Now, that's a bit of a stretch in my view, but anyway, they then make a complaint, withdraw the complaint, make a complaint, withdraw the complaint, make a complaint again. Now, there's a very, very activist Department of Public Prosecutions in one of these jurisdictions, and they effectively salivate at the thought of these cases, particularly if it's a straight white male who's being accused. I mean, wow, it's got everything. So when you look at the reporting, the media reporting, and when you do a search, online, the only stories you get are the ones that are very sympathetic to the woman and the evidence. Now, if the woman says, well, I don't really remember what happened, well, that's because she's traumatized. She's traumatized, and that's why she doesn't. It's too painful for her to remember, but that doesn't mean he didn't do it. Just because she doesn't remember it happening doesn't mean it didn't happen, because she's too traumatized. And don't you let the damn fucking fascist Nazi off the hook. He's a straight white male, and he deserves to be. We got to send that motherfucker to prison. If we haven't got any evidence, who cares? He's a straight white fucking male. He's Hitler. So then, in the evidence might be, I didn't do this because I was just too frightened. Oh, I didn't do it. Oh, I was so frightened. I felt fear. I was fear. I'm just a little girly. I'm a little girly. I've got no social power. I felt fear. So that's why I didn't do any. But what about, when you didn't do this or have that? What about so-and-so and so-and-so? I mean, you've got no fucking case here, girlie. Oh, it's because I was so frightened. Oh, don't you question me like that, you naughty bad lawyer. Oh, no, I'm just a little girlie. I've got no social power. You're not allowed to talk to me like that. I can make any accusation I want, and you have to believe me. If you don't believe me, lawyer, that means you're fucking Hitler. And on it goes. And it turns into a fucking circus, But anyway, we'll see what unfolds here. But the media coverage is astonishingly sympathetic. And, Billy Bob denies it. Yeah, you would, wouldn't you, you fucking Nazi? No sympathy for Billy Bob at all. None. Not a word of sympathy for Billy Bob. Or even balanced reporting. They may use terms like alleged rape. Billy Bob denies it, and those sort of things. But nearly every word that's uttered or written in this coverage, which again, if you Google it, only the stories that are sympathetic to her appear. Then the coverage is very much, well, he did it. If there's no evidence to prove he did it, who fucking cares? And if she can't remember what happened, just because she's traumatized, if she behaved strangely and weirdly and behaved in a way that suggested she wasn't raped at all, that's only because she was afraid. So every bit of slack, every benefit of the doubt must be given to her, while not one smidgen of the benefit of the doubt must be given to him. Now, as long as you have cases that are being reported like that, where ideology has crept into that point, then they are not legal cases. They fail absolutely in their duty of due legal process. And if that's the only way we can get convictions, then we're all in deep shit. You've been with Tacitus today in your Pushback channel, and thank you for listening.